Hello, my name is Benjamin Hart. I'm an American attorney, and I'm also the Managing Director of Integrity Legal here in Bangkok, Thailand. This video is designed to provide a brief overview of what are called consular reports of birth abroad. A consular report of birth abroad is very similar to a birth certificate issued in the United States. However, a consular report of birth abroad is issued to an American born overseas. An American can be born overseas by having their parent transmit that parent's nationality, United States nationality, United States citizenship, to the child by birth, even though that child is born abroad. There are some rules with respect to consular reports of birth abroad and automatic transmission of nationality to a child abroad, and I'll briefly sort of sum up the situation right now. When a child is born abroad to an American citizen or American citizens, the determination has to be made by the consulate in a given country. The American Embassy here in Bangkok has a consular section which can handle those matters. American Citizen Services can issue consular reports of birth abroad. There are various posts throughout the world, embassies and consulates general, etc., that can also help in issuing consular reports of birth abroad on Americans born abroad. One of the major issues that comes up with respect to U.S. nationality and the conveyance thereof overseas is the issue of whether or not the American citizen has the ability to transmit their nationality automatically upon a child's birth abroad. Basically, the rule of thumb is that the United States citizen needs to have spent 5 years physically present in the United States prior to that child's birth abroad. The United States citizen conferring citizenship needs to have spent a certain amount of that time in the United States past a certain age in the United States, and I can get into that at a different time. We can go very deep when it comes to consular reports of birth abroad and American nationality law, but the best way to sum it up is one needs to have been in the United States for 5 years in order to automatically transmit their nationality abroad. They need to have spent an aggregate amount of time of 5 years in the U.S. and then, okay, they're outside of the United States. For example, here in Thailand, they have a child and they're looking to have that child's nationality recorded with the U.S. consulate. A couple of issues with respect to that, one can be denied citizenship, or a couple or a person may not be able to transmit their citizenship automatically. In that case, this would result in a denial of a consular report of birth abroad, or CRBA. In the event of a denial, there's certain things that can be done to possibly remedy that as far as the child's citizenship goes, or United States citizenship goes. There's another video on this channel with respect to the Child Citizenship Act. I strongly recommend the viewer viewing this video go ahead and view the Child Citizenship Act video, because in the event of a consular report of birth abroad denial, the Child Citizenship Act may weigh in on the child's nationality. So I recommend that those who are watching this video go ahead and check out that video if that's a question for you. Finally, sort of with respect to CRBAs, sort of generally, an appointment needs to be made with American Citizen Services that has consular jurisdiction over the couple. In the event of a child born abroad, generally the United States Embassy wants to see both parents in person when undertaking the adjudication of the consular report of birth abroad. That's including the foreign parent. In this case, or in the case of Thailand, the Thai spouse or significant other. In the case of third-party nationals, that would be that person as well. So they want to see both parents generally at the interview for the CRBA, as well as obviously the child. And one may or may not be required to prove their physical presence in the United States in order to have the consular report of birth abroad issued. Finally, there's also the issue of DNA testing. Under certain conditions, it may be required by the American Citizen Services, the consular officers at any embassy abroad, it may be required that DNA testing be done on both the child and the American citizen who's trying to transmit their nationality. In the past, this was not as prevalent an occurrence. At this time, it's not unheard of that DNA testing can be routinely requested. This happened to be the case involving children who were born by way of in vitro fertilization and various other methodologies of conceiving children. In those situations, DNA testing was often required. So for those interested in obtaining a consular report of birth abroad, I highly recommend checking out the United States Embassy's website in your jurisdiction and making an appointment to visit the embassy, the consular section specifically, American Citizen Services, and undertaking the adjudication process for the CRBA. Thank you.